Hi, I'm Georgia Carroll, and I'm continuing on with our Family Law A to Z series with words commencing with the letter P, starting with pre-action procedures. As in the last vlog, I spoke about parenting, which is obviously a large portion of our practice, so have a look at that if you're interested. So pre-action procedures relates to what you have to do before you go to court, in effect. Now, that's great because a lot of clients come in and are desperately not wanting to go to court, and in fact a lot of people are terrified of that, which isn't a great thing because sometimes matters do end up there, and that's fine, and sometimes you need to do that for matters of accountability and to matters of urgency and where you need to really push someone to get something done. Now, the good news for those clients that don't want to go to court is that usually there's a number of things that need to take place prior to commencing those proceedings, and they are your pre-action procedures. So in property matters, so your division of your assets, otherwise called financial matters, you're required to attend to a number of steps. Now, those steps include writing to the other side, making an offer of settlement to them, providing them with a copy of the pre-action procedures and the compulsory court brochures, such as you may have seen the marriage family separation brochure, the duty of disclosure brochure, and so forth. You're also required to make a genuine attempt to settle the matter, which often would mean engaging in dispute resolution, and you're required to give the other party 14 days to respond to your offer of settlement. Now, another important factor as part of the pre-action procedures is your duty of disclosure. Now, normally we talk about this in relation to financial matters, and absolutely that's where it comes up more often than not because you're exchanging bank statements, tax returns and so forth. There's a list of that outlined in the family law rules in the schedules for you to have a look at as to what needs to be exchanged. However, it also relates to parenting. So in parenting matters, you have a duty as a party to those proceedings, and even before the proceedings begin, to disclose anything that is relevant to the matter, and that is an ongoing duty of disclosure. So that's both parenting and property. They're pre-action procedures, but those duties with respect to disclosure apply throughout. Now, if someone doesn't comply with the pre-action procedures, you have to have a pretty good reason as to why you didn't. So normally that would relate to matters of urgency, i.e. someone's about to sell my house from underneath me, or the mortgage is not being paid, or someone's taken my child. They would be matters of urgency. Or there have to be other reasons that would preclude your attendance. So for example, that might mean that you are a victim of domestic violence, or you're unable to get in contact in any way after many attempts with the other party to even attempt to have those discussions. So there are exceptions, but generally speaking, if you come and see a lawyer, we're going to talk you through the pre-action procedures and say, you know, you've got to send 1 to 2 letters outlining a number of things, and genuinely endeavour to settle the matter before you can actually commence proceedings. So for the clients that don't want to go to court, that's good news. It means you have great prospects of trying to resolve things beforehand, and look, most matters ultimately do. So it's positive that the Family Law Act and the courts are geared towards trying to want to steer you away from actually being involved in court proceedings, because once you're there, everything becomes a little bit more conflict-based, as opposed to resolution focus, which is what we like to try and focus on when we're trying to negotiate in the early stages of your matter, so you can get you and your family out of the process and out of the system and moving on with your futures beforehand. So that's what these pre-action procedures are designed to do, and they're designed to try and narrow the issues between you before one of you does have to commence proceedings in court. So next time I'll be talking about word starting with the letter Q, and I'm going to be focusing on some family law commonly posed questions that we receive. Thanks, bye.